The fourth ground on which there can be frustration of a contract is non-occurrence of a particular event. The doctrine of frustration also applies to cases concerning the cancellation of an event which forms the basis of a contract. It is possible that the performance of a contract remains entirely possible, but owing to the non-occurrence of an event contemplated by both parties as a reason for the contract, the value of the performance is destroyed. In Krell versus Henry, the plaintiff agreed to let a room to the defendant in Pall Mall for the days on which the processions planned for the coronation of King Edward VII were to take place. Both the parties understood that the purpose of the letting was to view the coronation procession, but this was not expressly stated in the agreement. The procession was postponed owing to the illness of the king. The contract was frustrated when the processions were postponed. The performance of the contract was not physically impossible because the defendant could have used and paid for the flats on the days in question. The court, however, took the view that the procession was the foundation of the contract and that the effect of its cancellation was to discharge the parties from further performance of their obligations. It was no longer possible to achieve the substantial purpose of the contract. However, the contract must be deprived of the whole commercial purpose to amount to frustration. For example, in Herne Steamboat versus Hutton, the defendant hired out the Clement Tea ship. The purpose of the contract was to take paying passengers to view the naval review, which was part of King Edward VII's coronation celebrations. The defendants were also offering a day's cruise for the passengers. The naval review was cancelled as the king was ill. The defendant did not use the steamship and the claimant brought an action for the agreed contract price. The defendant argued that the contract had become frustrated due to the cancellation of the naval review. The court held that the contract was not frustrated. The contract had not been deprived of its sole commercial purpose as it was still possible to perform the contract. The fifth ground is legislative or administrative intervention. When any legal or administrative measure is undertaken which has such a drastic effect on the fulfillment of the contract so as to completely transform the contemplated conditions of performance, the contract will be frustrated. For example, in Pothalinga Agencies versus VTC Puraiswamy Nadar, the defendant had a license to import chicory for manufacturing coffee powder. The license was subject to the condition that he would use it only in his factory. He agreed to sell the whole shipload. Before the arrival of the ship, the sale of such imported goods was banned. The contract was accordingly held to have become void. But an intervention of a temporary nature which does not uproot the foundation of the contract will not have a dissolving effect. This is shown by the decision of the Supreme Court in Satyabrata Ghosh versus Mugni Ram Bangur and Company. The defendant company started a scheme for the development of a piece of land into a housing colony. The plaintiff was granted a plot on payment of earnest money. The company undertook to construct the roads and the drains necessary for making the land suitable for building and residential purposes, and as soon as they were completed, the purchaser was to be called upon to complete the conveyance by payment of the balance of the purchase money. But before anything could be done, a considerable portion of the land was requisitioned by the state during the Second World War for military purposes. Justice Mukherjee held that the contract was not frustrated. The court observed that undoubtedly the commencement of the work was delayed, but the delay was not of a nature or such duration that it would totally upset the basis of the bargain and the commercial objects which the parties had in view.